it seems like, in addition to all of the issues in the lawsuit about, how we should determine bond and that sort of thing, and trying to get people out on pretrial release as often as possible, it seems like a lot. Yes, I think we all agree on that. We saw what happened with the misdemeanor lawsuit, but you pinpoint a lot of fundamental problems that, okay, great, even if we resolve this lawsuit, and we all agree, and we settle it, and we say, yeah, we want to do all that, we want to get it done, we physically can't do a lot of it.
Exactly.
That's right.
Exactly, and nobody's thinking about any of that. They're wanting to put the cart before the horse, and actually we are working with the plaintiffs' attorneys. We're very happy what happened in with the misdemeanor courts. That should have never happened. Pretrial bonds for misdemeanors all day long.
Yeah.
We're in favor of that. As felony courts, one of our biggest concerns is safety of the victim and safety for the community. And so it cannot be one size fits all. We cannot be like the misdemeanor courts and just let everybody go. So we're actually working with the misdemeanor courts. They would love for us to be, and I would love for us to be able to be like the federal system, where we have a hearing and determine if someone is a danger to the community, and not have to give them a bond.
And guess who could do those hearings? Associate judges.
Well, there was recently.
I mean, that's essentially what the magistrate judge in federal court does.
Yes.
I mean, they will conduct initial appearances, conduct detention hearings. If authorized by the district courts, they'll take pleas and then write a report and recommendation as to why the district court should accept the plea, and then the district court will do the sentencing. So there's no reason why you couldn't model that same system.
Well, I mean, the state constitution would need to be amended.
Yeah.
How was that and why?
Well, because right now the state constitution requires us to give a money bond, set money bond.
Understood. Got it.
So we need the legislators to help us. We need everybody to help us follow the law as well. So nobody was taking any of this into consideration right now.
Was the lawsuit on the federal lawsuit from the felony side, was that a surprise, or was that something that
we're actually not named as a party.
Right.
The sheriff's department and who else is
Just
named?
the Harris County.
Court, right?
Yes.
It's just Harris County.
Yes, it's Harris County, but they haven't named us because they realize that we're in a unique position and that we do deal with serious felony cases. And so they're working with us very well. And
Well, and I think they were surprised when we did meet with the plaintiff attorneys and Judge Jackson initiated that in 2017, my class's first year, we sat down and we did carve-outs on the felony side of what are considered, in our opinion, nonviolent crimes. And from January of 2015, just to give you an idea, from January 2015 until this year, personal bonds on the felony side have gone up 444%. And those are dealt with on the low to moderate risk individuals. And we've got two main things with bonds. We want you to appear. You've got appearance and safety to the community.
yes.
And as Judge Jackson just pointed out, our state constitution requires a bail system. And a lot of the, I don't want to say rhetoric, but a lot of the conversation talks about, well, everyone needs a pretrial bond, or if there's such a danger, just keep them at no bond. Well, we can't do that.
Right.
There's only 4 instances in the Texas Constitution that allow a felony judge to keep someone at no bond, but only for a limited period of time. Even with capital murderers, alleged capital murder offenses, we can't keep them at no bond either. And a lot of people are surprised by that. But you have to look at, okay, what is this person's likelihood of they're presumed innocent, but are there priors one after another? Okay, and so what is their risk? We run a risk assessment, which is also new since the filing of the lawsuit in misdemeanor that I think a lot of people don't know about.
Is it the same risk assessment that misdemeanor uses, or is it different, and how is it?
It's the same.
Yes.
So it takes out, it's definitely focuses on equality and fairness. It takes out someone's ethnicity, their gender, anything of that sort. It focuses more on what are they charged with? Do they have any priors dealing with violence? Do they have any failure to appears in any court, whether it's misdemeanor or felony? So you're looking at broad-based risk assessments and determining, okay, what's the best for them? So, and I know Judge Jackson probably does the same thing. You have to look at each case individually and have a thoughtful based conversation with both sides to figure out what's the fairest way for that individual and for the community. And it's so much more difficult in felony.
Judge Johnson, what do you mean? You were my chief prosecutor. You know, I have both the state and the defense present when we're discussing bond, always.
Well, I meant that. It said
Yes.
both sides. Yeah, you have both sides conversation. I thought I said that, but who knows? But yes, you have to have a conversation with both sides to figure out, does this person reside in Harris County? You know, do they have connections with another country? Meaning, are they, you know, is there a sense that they might flee? Those are all conversations that you have to have with both sides.